We have audio,
Don't have video yet?
not yet.
No, sir. We do not see you.
There you
There
go.
you
Now we got
go.
it. We're
We see
done. We're
you.
ready.
See you and
I
we
never
hear
had
you, right? Would you
so
like
many
to reserve
complications.
any time, Mr. Dandar?
5 minutes, please.
Yes, sir. You got it. Go ahead, sir.
Good morning. I'm Ken Dandar, and this case has been a nightmare for me. I've been an attorney in Tampa Bay since 1979 and met my client Peggy Hawkins at church through our Monsignor, and I represented her for many, many years. And I found out that she had two sons out of three who were drug addicts and alcoholics. And she asked me to help her take care of them. And so I did.
Well,
And
let me just get to the chase. What's going on with the accountings? You never provided the accountings for the longest time. The preliminary
I,
accounting, then no accountings thereafter.
I didn't provide an accounting. I thought her CPA, who she's had for many years, would help me provide an accounting. And when he said no, he said, that's a specialty. I had no idea who to turn to. I went to Mr. Dixon.
But
I
you were
paid
the
him a
trustee, right?
I'm the trustee. I've never
Whose
had a
duty is
trust
it to
like this.
provide the accounting?
Pardon me?
Whose duty is it to provide the proper accounting?
I am as a trustee. Yes.
And then you took fees for the work you performed pursuant to a trust created in 2009 that was never funded. Is that correct?
Well, that's all. No, the 2009 trust was funded because it owned a motel and made money that way through the motel. But I never charged her for those 2009 to 2017 fees um, while I was incurring them to take care of her son and and then uh, take care of the son who was in a condominium that she bought for him when he divorced his wife.
But the trial court
That's the
rejected you made those arguments below, correct?
I made these arguments below.
And the trial
I
court rejected
provided the
them all.
court I provided the lower court with a declaration that explains all the different accounts. And I also provided time records, and the court refused to look at them
Yeah, but
because
if
I
you're
missed.
late in providing the accounting, the trial court basically could have done what it did on that basis alone, correct? It didn't have to listen to the arguments you're making to it or making on appeal.
It didn't look at my accounting that I did because it was too late. Even though I filed it in ahead properly timely and ahead of the motion hearing for summary judgment. And I asked the court to even let me go to the forensic accountant, Purcell, because she made so many mistakes. I said, let me sit down with her and we'll have a proper accounting done. And the trial court, or probate court below said no. And so I couldn't get Mr. Dixon to return my phone calls. They called him. I don't know what they said to him, but I couldn't get him, the CPA, to do an accounting for me. And I couldn't get the court to let me talk to Purcell and do an accounting. And I have all my time records, all the expenses, and that's why I finally filed a motion to dismiss based upon fraud on the court, because the substitute uh, trustee, Miss Diamond, she knew that I purchased a home on a golf course for an excess of $500,000 for the daughter, the adopted daughter, Miss Word, the plaintiff in this case. And I bought that house for her at her request, paid cash out of the trust. And the trust was a remainder interest. She had a life estate with her husband to protect her. And Purcell, the accountant that Diamond hired, knew this. And they knew this for years before this hearing. And yet they put down on there that I'm being charged for this $500,000 home. I paid off the mortgages on Peggy Hawkins, the decedent, the settler. I paid off her mortgages on her home. I'm being charged for that. And
I
one
had a
of the
question
most,
for you. Can I interrupt real
yes,
quick and just clear up? And this may reveal some ignorance on my part of the record. You can clear up. So that was excluded essentially, for lack of a better term, because of the cutoff and that was imposed upon you. I think. But why didn't you assert that earlier in litigation? Why
assert
didn't
what?
you produce that documentation earlier?
Um, Well, I had to create the documents.
No, no, but
I had
not
to,
created. I mean, there were just existing documents, right? That there was like, closing documents or something that supposedly evidenced that this was properly, that this was a proper expensive use of trust funds.
well, that's
Why
my
didn't you,
mistake.
why didn't
I
you
should,
assert that earlier? I
I
mean, you're
should have
saying
done
that
that.
after the fact. Well, look at this. Here it is. It's the smoking gun. This was proper use of trust funds. But I don't understand. I just don't understand. Why didn't you said, well, I couldn't get the accountant to do X, Y, and Z. Well, why didn't you just show that to the court?
I should have done that. You were absolutely correct. It's a public record that she owns the house. The house is in her name. That's a public record, but I
By
should
the way,
have done it.
by the way, I'm not, I just wanted to say I'm not opining on whether that is proof positive that it was a proper use of trust funds. And maybe it is, maybe it isn't. Uh, I'm not, it doesn't matter to my question, but you understand that. But so you're saying what now? It was public records. Doesn't that support that that it's a mysterious that you didn't assert it earlier?
I asserted it at the hearing and I asserted it in my declaration that I filed opposing the summary judgment. And I'm asking the court to reverse the summary judgment, reverse this multi-million-dollar judgment against me, which is destroying me, and let me go back with their accountant and sit down and go through all the records because all of it is accounted for. In my declaration, I filed at record 1310 to 1376. It shows all of my time records uh, that I expended.
Well,
And
what is the standard of review in this case? Is it
is
abuse
there
of
an issue of
discretion?
material fact?
Okay,
That's the
so,
standard.
and the trial court found that you didn't present any admissible evidence.
He ignored what I filed in opposing the summary judgment motion. He wouldn't even look at it. And it's a sworn declaration by me, and it's all my time records attached to it.
So you're saying that was admissible evidence,
Yes,
even though the court said it wasn't admissible?
he wouldn't look at it. No, he just said, I'm not looking at it.
Is that because it was adduced prior after the cutoff hit the court imposed?
It was after the cutoff. Yes, it was after the cutoff.
Well,
And he asked to
at
go.
one point, didn't you also testify you don't know the law on trust?
I don't know. I may have
Okay,
because I never
okay.
had to do this before. This is my
Well,
first time,
yeah, that's probably a good reason why you shouldn't be doing this, but
and I don't do it. I just did. She was my longtime client, and she asked me to do it, and I said okay. She had because of the two sons, but primarily
well, that's
she
another
was
issue.
this.
Okay.
One tried to kill her, and he ended up hitting a cop over the head and went to jail and escaped several times. He's now in Florida. But
Mr.
the
Dandar,
other,
Mr. Dandar, I don't mean to demean any of that. What you've done is laudable, but it really doesn't have anything to do with the lack of accounting. Whether or not you had experience or not, you didn't. The law requires you to do the accounting. This judge gave you a period of time to gather all the records that you possibly could. And also you were presented with the expert accountant, Brazil or whatever her name is, her findings to go through that and pick through that. Yet you filed the declaration after a deadline, and a deadline the judge said that the court would not consider it. So how is it error when you're given a deadline to file something? And if you do not comply, the court will not consider it. You file after the deadline, the court doesn't consider. I don't see an error here. I understand the judgment against you. I understand the stress. I understand that you care for these people. But there is no error not reviewing your declaration. That was clearly within the order, telling you, get the accounting done. If you don't, and you submit anything after this deadline, the court will not consider it. Is that true?
oh, the court gave me a deadline, but the declaration should have been considered
But
because
it
there was no
filed
deadline.
after the deadline, correct?
The declaration was, yes.
Okay, I don't see an error. So let's move on. Where are the other errors?
Well, the other errors are So if someone can get a judgment against me because I missed a deadline, then I probably I'm not going to be able to get away from this multi-million dollar judgment against me. Um, hold on just a minute, please. I filed more. I don't believe the surcharge statute permits a surcharge because I can account for all the expenditures. This is what I'm trying to say. I missed a
You
court
had a bite,
deadline.
you had one bite at the apple. You don't get two bites at the apple.
Well, I
Argument
should
you're
have
making now, so give me another shot at this.
I should have a second bite with all of the documents I have showing all the time I expended. It's not like I
Okay, wait
put
a
it in
second.
my pocket.
You're not being charged with a criminal theft. So if you were, then you'd get a second or third bite at the apple, but this is a trust case. Supposed to
But
be
there's
decided by
material,
the trial court first, and we agree or disagree with the rulings.
but there's material issues of fact. I did file a declaration, which I was allowed to do to oppose the summary judgment. And in that declaration, I detail where all the money went to separate accounts because one account was for me for trustee fees. I even out of my personal account for trustee fees, I paid Carla Werr because she demanded money right away. She had emergencies, and I just wrote a check to her, or I transferred it to electronically because she demanded so much from me, and I just went ahead and did it. And then Kenny Hawkins, had to hire someone to take care of him in his mother's house, and I set up a checking account for him, but I had to put it in my name because he was too incompetent to go into a bank and open up a checking account. So I did that and I transferred the money, yet I'm being charged for all this. And it's not right. And as a fundamental right, this whole thing should be reversed and let me go to Purcell and sit down with her, court appointed, and put all this out on the table. Although I believe she had all these records before the summary judgment hearing, and she just puts down she doesn't do a forensic accounting. That's number one. Number one is there's no forensic accounting. All she does is list all of the checks from the checking bank accounts, and she doesn't put down where they're going to. And sometimes, well, she puts down like the taxes and the Bank of America for the house for Carla and things like that for the closing. But all the other ones, like for Kenny Hawkins, she charges to me. She can charge to me for my trustee fees. That's okay. For taking care of Kenny Hawkins in that condominium so he doesn't get arrested for drugs and alcohol dealing. I mean, that's okay. But that's not okay because I spent those years in that condo almost every day making sure he didn't get arrested. I even had to go to
let me
the
ask you
condo.
this. So there, you could conceivably break down the expenses into two categories. One, and which is funds just that went directly to some other third party, like to buy a house, or to. But the other, but of the category of funds that went to pay you for services you rendered, the opposing counsel in its brief spoke thoroughly about whose burden it is to prove that those fees were justifiably spent out of trust funds. And you're saying that you spent time in the apartment, you did all these things, you helped them set up a bank account, but you were charging an attorney's fees rate for that. Isn't it your burden to justify that to help some a beneficiary open up a bank account that's justifiable if you spend $450 an hour?
Judge, I'm charging the same hourly rate she's always paid me for over 20 years. And the current trustee, Miss Diamond, she charges $450 an hour. And the trust that I set up
to help one of the beneficiaries open up a checking account.
Well,
to sit in, what were you doing in his apartment?
Well, one of the times I was in the mother's house, he was laying on the floor almost dead, and I had to call 911. But I don't know if I charged for that. That's when he went to the emergency room.
But
they saved his life.
So things like that, whose burden is it to justify the hourly rate spent to pay the trustee himself or herself to render these services? Whose burden is it to establish that that's reasonable use of expense of trust funds?
It was never challenged. They never challenged my hourly rate. And it's always been my hourly rate. The settler set it up that way. And the trust that she signed, both trusts, gave the trustee the discretion on who to pay and how much to pay. And it was within the trustee's discretion. It's a form. I don't think it's something new, but I had discretion as trustee. And there was no one else to take my place to get all this done. To get the
Mr. Dandar, you're at 15 minutes. You can go ahead and continue.
No, I'll reserve 5. I'm sorry.
All right, sir. You may. Good morning, Mr. Elegant.
Good morning. May it please the court, I'm Tom Elegant. My partner, Amy Ferrier, is behind me in the background here. We represent Sandra Diamond, the court-appointed special.
I'm just watching the OAs.
Morning.
I'm sorry, what was that?
She's watching the OAs.
Mhm.
That's irrelevant.
Okay, okay. Anyway,
Yes, and that's because the other 2 TVs were used before COVID for
We don't know
we
who's
were
talking.
using
It's
them
I'm
someone
sorry,
else.
that's our IT person. I
our
don't know
meeting
why.
rooms.
We can
okay.
hear her. I'll see what I
What?
can do to fix that.
Goodness, elegant.
Okay, the rest of the trial team represents Kevin Hawkins and Carla Wurr, and they're watching by video. So I'm almost tempted to say it's apparent to me that the full panel gets it, and this should be summarily.
How about if
affirmed.
you just hone in on the summary judgment standard?
Yeah,
Was that
yeah.
satisfied in this case, and was it the new rule? What are we talking about?
Absolutely the new rule, Your Honor, and that's why because the defendant had the burden, as the court's already discussed, to come forward and justify these expenses and to do it in a timely manner. When he failed to do that, the court was well within its rights to say, hey, you didn't put the evidence on, you have no admissible evidence that supports your position, and summary judgment was appropriate. I mean, he didn't do it just based on that, he did it based on the arguments and the showing of the plaintiffs. And let's talk about that for a minute. Everything that happened here is the defendant's fault. Okay, he didn't maintain the documents. He didn't produce the documents. What he did produce wasn't timely, and it was untimely, unauthenticated, and unreliable. Okay, and that's $2.6 million that he has been charged with. Now, of that, and you didn't hear anything about this, of that, that's $1.5 million that he paid himself, paid to himself or his firm. And then when he was asked if he reported that to the IRS, he took the Fifth Amendment. Okay, we don't have to show he misappropriated the money. When the trustee fails to account, it is charged to him. He had the sole duty and burden to account for all these transactions. It's not the job of somebody else, Ms. Purcell or Ms. Diamond, to ferret that out. By the way, that's why we filed the Supplemental Authority of Black's Law Dictionary on forensic accounting. This was a forensic accounting. Forensic accounting is just the application of accountancy principles to monetary issues that arise in courts. That's what this was. To the extent he wants to complain, it could have been better. That's his fault. He didn't provide the documents. Okay. And in fact, I mean, if they hadn't ferreted out, which is not their job, if they hadn't figured out the Soho thing, there'd have been another $600,000. So he got a benefit from that because he admit there's really a simple answer to this appeal. You heard him say that the relief he wants, and it's the same thing he says in his brief, is to have Purcell go back and work with him to do an accounting. Okay, that ship has sailed.
Well,
All right.
their argument, according to the attorney below, went to damages, not to liability or culpability, correct?
Exactly, Your Honor. That was the next point I was going to make.
Sorry,
His
I didn't-
counsel, this is page 69 of the transcript from December 2022. It's in our appendix at page 69. Admitted the only question is the amount. Okay, he has not asked for this court to visit the amount. He has not said, oh, well, here, this was too much. this is a specific thing. I proved this. I had admissible evidence to show this was too much. He hasn't done that. The only thing he asked for is to go back and start again, which he's not entitled to.
That's not relief we generally grant.
That's right. That's correct. I mean, that ship has sailed. And because that's all he asked for, he hasn't asked for anything else. And the simple answer, he hasn't asked for the other relief, so it should be affirmed.
Well, I mean, to be honest, it sounds like there may be a morality issue. Maybe there's something done wrong, but that's not the standard of review that we look at.
If you're saying, did the trustee here do
Well,
something?
he claims he's at the condo every day. He helped his son. His son had drug issues. He ran to Mexico,
Well,
kept him out of jail. Well, he did a lot other
Well-
than misapply the rules.
yeah, Your Honor, you look at those time records, they go all the way back to 2009, where he's testified under oath, the trust didn't have any assets, the 2009 trust. Now he tries to change that at different times. So it depends on which testimony or statement you look at. But the trust required a written direction for a distribution during Peggy's life. So all this money that was spent then wouldn't have been valid anyway. And again, $1.5 million to himself, won't say if he reported to the IRS. What does that say? Okay, on the house, he says, "Oh, I paid $525,000 for a house." Well, in his amended appendix at 467, there's a document that shows if you believe it, it's untimely, it's unauthenticated, but if you believe it, it shows 525 paid in 2018. In Ms. Prezell's and Diamond's, I think it actually was Diamond's analysis, the property appraiser has that property at 377,000 in 2020. Property's not going down in Pinellas County between 2018 and 2020. And anybody who's familiar is going to know they assess those at near full value. So there's something funky going on there. Had those documents been produced timely, that could have been investigated, but they weren't. Again, untimely can't be considered.
But does it show that the trust bought the house?
If they are accurate, which they have not been authenticated. They're not, there's things he stuck in the record and too late, way after the fact. So that's the problem there. And again, the point is he did not timely account for them within the deadline when he needed to, so he does not get credit for that. Okay. He also, you talked about, you heard something about charging her this rate. He also testified he never charged her while she was alive. So, again, it's all over the place, Your Honor. Never billed her during his life. That's at page 957 of the record and the few pages after. I guess at this point I would ask, does the court have any questions? Because we would ask you to affirm.
Oh, thank you.
Thank you. Mr. Dandar, you have 4.5 minutes.
Your Honor, could I take a 2-minute break?
It's a comfort break.
Yes, please.
Okay.
Thank you.
Be in recess, 2 minutes. I'm tough on the clock. All right, we're back in session. Dandar, you have, what did I say?
I think your mic is muted. It's okay.
5
There you
minutes,
go.
4.5
right?
minutes, sir. Go ahead.
Okay. Judge, in our reply brief, we filed what was sealed by the clerk of the court at we don't know why it was sealed. And those records are my banking records, which Purcell had. And those banking records show how all of the funds were distributed by me as trustee to the beneficiaries and for the beneficiaries. And the judge refused to look at all those because it was sealed, I guess. And he refused to consider my declaration. This is a summary judgment. We should have a trial. There should be a trial on the merits,
Can I ask
not
you
a
a
summary
question?
judgment.
Isn't your argument, oh, I use the forms that the Florida Bar promulgates for trust, and therefore that should be good enough? Is that the gist of your argument?
No, I do not believe I said that. I used the forms from the Florida Bar. I don't remember saying
Well, I
that.
don't know where the forms came from. You said you use, quote, the forms.
I'm
We
not
can
sure
move
why.
on. We
All
can
right.
move on.
And Purcell had all the banking records. That's how she made her simple list of what the checks were written. And she guessed at where they went. And guessing was not good enough. She wasn't forensic accounting at that time. She was just doing a list of checks. And my appendix A and B shows after we got the clerks unsealed the records with consent of opposing counsel, the appendix shows that these are all checks written by me for the benefit of the
And
beneficiaries.
did you ever provide an accounting before the lawsuit was filed? Of any
before the
sort?
lawsuit was filed?
When did you file your first accounting other than the preliminary one in 2009, let's say?
I filed what I thought was an accounting in opposing the summary judgment with my sworn at declaration, and the court didn't look at it.
Because it was untimely.
It was untimely, and that's not. I don't think justice should play that way, and I think that may create. It's a summary judgment. It's not a trial. It's different if you were in a trial and didn't produce evidence that you had. But the accounting should have been considered by the court on a motion for summary judgment. There's issues of material fact. That's the standard. And then when I filed my motion for fraud on the court just summarily denied that as well. And it's obvious in what I filed exhibits, I'm being charged for an account of Peggy Hawkins while she is alive in over $300,000, has nothing to do with the trust. And yet I'm being charged for that under the Purcell affidavit. And that is a fraud on the court because there's nothing there that has anything to do with me as the trustee. Also, again, I'm being charged for the Carla Ware's house, and she's the plaintiff, and she knows darn well I bought her that house at her
Well, it sounds like an
request.
argument. I know, but it sounds like you're making an argument all over again that you made below.
I'm sorry.
I don't want to cut into your time. You got a couple
All right.
minutes left.
But all of this was in the file of the lower court of all these checks that I wrote from my checking accounts to and for the benefit of the beneficiaries, and it was sealed, and the judge never looked at it. So these are issues of material fact. And now that it's opened, we go back down and we'll get the judge now to look at all of this. And I think that would be the justice if he indeed is ordered to look at it, set aside the judgment, and let's proceed to a trial. Because I can document everything that I did, and I documented it in the declaration with the attachments, like 88 pages of attachments. And I also documented it in the getting the court to unseal the files. And those are the records that the court should have looked at, but didn't look at. And it shows that I didn't take any money. I spent the money appropriately on the beneficiaries and spent the money on my time. In fact, I discounted a great deal of my time. And
Right,
I
so
didn't.
you're right at the end of your time.
All right. I thank you so much.
Thank you
Thank you,
very
man.
much. Thank you both. We appreciate it. That concludes